Hello, welcome to Taxpayer Alert. I'm Al Segalla. I'm president of the Calaveras County Taxpayer Association, and I'll be your moderator this session. And we're excited about a new guest we have, Jonathan Wood with the Pacific Legal Foundation. The Pacific Legal Foundation has been in real wins fighting for property rights and fair treatment of people's rights. Jonathan, welcome.
Thank you for having me.
Jonathan, tell me a little bit about yourself and then a little bit about Pacific Legal Foundation.
Sure. I am a lawyer. I grew up in Texas on a ranch and transitioned from that to law, and I went to law school in New York. You know, basically went from small town to big city. I've been pretty much in every type of place you could possibly live. My specialty is environmental law, particularly Endangered Species Act litigation. It's something that's fascinated me for a very long time. I actually went to grad school at the London School of Economics, and my focus was on Endangered Species Act reform, particularly free market approaches to doing that. And so a lot of countries don't take the sort of command and control approach that we do here, where basically the federal government controls everything that's done that might affect an endangered species. But places like Namibia, for example, have been extremely successful focusing on establishing property rights, protecting people, and protecting free markets, so that you can have private conservation, something which we unfortunately don't have much of here.
I understand. I understand perhaps an application of free market preservations of species would be the private ownership of buffaloes.
Absolutely. Yeah, it's funny. There are a lot of species that would go extinct if not for private ownership. As I said, in Namibia, it's done wonders for the black rhino, for elephants, and the reason why is really clear. We're never going to have the cow go extinct because there are too many people that have too much money invested in it that they're not going to risk losing all that investment.
That makes sense. And perhaps we need to know, according to theory of evolution, extinction of species is part of the process of forward development of all species.
Exactly.
And so when we try to preserve a species that can no longer adapt, perhaps we're doing the wrong thing. There may be some reasons why a particular species could have some value to science, perhaps, but it would seem like if you were going to protect species, the most important thing you'd want to do is grow more of them. And not punish people because they may kill one or two. I'm thinking about some of these plants that have shut down really wonderful projects and things like that. So one of the wins that the Pacific Legal Foundation has done has to do with Obamacare. Tell us about that.
So I work for Pacific Legal Foundation. It's a nonprofit based in Sacramento. It's the nation's oldest and largest nonprofit that defends the Constitution, limited government, and free enterprise in the courts nationwide. And one of our biggest cases right now is a challenge to Obamacare. It is the last best hope to strike down the entire statute. We argue that something called the origination clause in the Constitution, which says that new taxes must be proposed by the House of Representatives, the politicians that are at the federal level the closest to us, because there are so many more of them and they're elected by smaller local elections rather than statewide elections. The founders thought this was a key protection to make sure that the federal government didn't increase taxes and increase the burdens they were imposing on us. Well, unfortunately for Obamacare and its supporters, the individual mandate, the statute itself, was not originally proposed in the House. The Senate prepared it, and the reason why was because they needed to act quickly because a Democrat had just been voted out of office and a Republican was going to come in, they were going to lose their supermajority in the Senate. So what they did was they took a House bill that had absolutely nothing to do with Obamacare or health care or anything like it. It dealt with subsidies to veterans coming home from serving abroad and their attempts to buy their first homes. They took that bill, struck out everything but the number at the top of it, and replaced it with Obamacare. And they claim that that process is consistent with the origination clause, that this key protection the founders put in the Constitution is that easily circumvented, and we think that's wrong. That taxes like this must generate in the House, and that didn't happen here. And if we're right, the entire statute is unconstitutional. Right now, we're litigating the case in the D.C. Circuit, which is often considered the second highest court in the land. We've asked the entire court to look at it, and if they won't, ultimately we're prepared to go to the Supreme Court and try to get this issue finally resolved.
Boy, that would be wonderful to allow, actually, to allow freedom to return to medicine. Mm-hmm. I've seen advertisements on TV saying that health care is a right. Mm-hmm. You have a right to health care. Well, that means you have the right to enslave a doctor or a nurse. Mm-hmm. If they don't want to give you health care, you can't force them to do it, mm-hmm. just as you can't force a person to paint your house mm-hmm. or clean your floors or anything else. It's so wrong to use the collective approach to abuse individual rights, because the consequences constantly turn out to be unanticipated and hurtful.
That's absolutely right. Regulation like this basically stymies innovation. So one of the things that people often overlook is that before Obamacare, before we adopted a medical system much like Europe's, the U.S. was leader of the world when it came to innovative medical procedures. You could get essentially any procedure you want in the United States. That was never true in Europe. There you could only get the procedures that the countries approved of, that the government said, this is what we're willing to pay for. And we're going to have that here soon, something called the Independent Payment Advisory Board, which is what was called the death panel during the negotiations, will dictate what procedures can be paid for and can be covered. You know, this is something that's been a problem throughout the history of federal regulation of medicine. Starting in the early 30s, the federal government began to regulate the introduction of new drugs. And made you go through extensive steps and studies, and basically you had to get a federal approval before you could introduce a new medicine. And that is the reason why insulin, the treatment for diabetes, was developed not in the United States, but in Canada. At the time, the prescription for diabetes was to slowly starve yourself to death. It was an incredibly cruel treatment. It was essentially torture. But we didn't know any better. And then a scientist in the United States came up with the idea of generating insulin, but he couldn't get it through the federal regulatory regime. He couldn't jump through all those hoops. So he had to go to Canada instead. And so people died, another years, maybe even as much as a decade, people in the United States were stuck with this old, terrible treatment and didn't have access to a great medicine.
Wow, that's really, really, well, it's good news that you might be able to turn this around.
Absolutely.
And also, by their deeds you know them. And as an unwise law is applied and people suffer from it, there'll become a point when they realize that it is an unwise law. Mm-hmm. And it's just a question of there being enough people, and maybe doctors, that care enough about medicine to help turn it around and get back to free medicine. Mm-hmm. But moving from Obamacare to cap and trade tax. Mm-hmm. Now, that's another thing the Pacific Legal Foundation is involved with.
Yes. So in the last decade, the California legislature adopted something called AB 32, which was designed to reduce greenhouse gas emissions across the state. And like many modern pieces of legislation, it was incredibly broad and vague. It basically left to an agency down the road to actually decide what was going to be done. The legislature just adopted something that announced a problem and then patted themselves on the back for having not really done anything. My colleague at Pacific Legal Foundation, Tim Sandifer, likes to compare the legislative process to if the legislature adopted something called the No Bad Things Law. It would be a statute that says there should be no bad things, and the second provision of the statute would say there's now a no bad things agency. It needs to identify those bad things and regulate them out of existence. And that's what happened here. The legislature was concerned about greenhouse gas emissions and climate change, so it adopted an incredibly broad statute and just deferred to the Air Resources Board to do essentially whatever it wants. And what it did was enact a massive new tax, cap and trade, where if you want to emit carbon dioxide, which all of us do and essentially everything we do does, you have to pay the Air Resources Board. And so far it's already generated over $1 billion, and that's only going to increase over time. And it affects all of us. Recently, in the past few months, it began to apply to the gas that we all put in our car through refineries. And so this is something that's going to increasingly expand and affect all of us and make everything more expensive. And the unfortunate reality for Air Resources Board and for the legislature is that the AB 32, the legislation that made it possible, wasn't adopted by a supermajority. But we have protections in our California Constitution that say that new taxes must be passed by 2/3 majority in the legislature. Otherwise, they're unconstitutional. And that's what happened here. A bare majority passed AB 32, authorizing the Air Resources Board to impose an incredibly new burdensome tax. You can't do that.
You know, more fundamental in all that, if there really was a continued global warming, and it was really proven that carbon dioxide is a poison, not a nutrient, then maybe it could make sense to try to regulate it some way, or prevent it from going into the atmosphere. But we have so many scientists now, they're called skeptical scientists. As soon as I think all scientists that are honest are skeptical, because if you're not skeptical, you're not doing science. Science cannot be driven by hopes and dreams. It has to be driven by facts and analysis and comparisons and blind studies. And so we have the skeptical scientists saying that there has been no global warming since 1998. But for the news media, most people don't know that.
Oh, and of course, it's something that can be explained away. Now, we at Pacific Legal Foundation, we're lawyers. We're not scientists. We can't, like, when I try to read documents, scientific documents like that, my eyes just glaze over. So I can't pretend to say who's right on that issue. But we think everyone should be able to agree that regardless of whether climate change is happening or not, constitutional protections for individual rights must be respected. That it's not an excuse to throw out the Constitution. You don't want to throw out the metaphorical baby with the bathwater.
Oh, I can understand that, and I suppose that is really the rational way to approach it. But the amount of harm done to our economy by that AB 32 is so drastic that I only hope that you can win that lawsuit before more damage is done.
Yeah, the $1 billion they've already sucked out is only a drop in the bucket because it ignores where they're spending the money. So they're spending the $1 billion on things like high-speed rail and other destructive and wasteful government projects, and they're driving businesses out of business entirely because if you can't afford to pay in the auction for the permits, you just have to go out of business. And that doesn't show up in the $1 billion, but that's real lost economic growth.
Right. Our former guest, John Coppell, talked about the number of businesses that are leaving California because they can no longer stand the level of taxation and regulation. And on the regulation part, you seem to be trying to hold the line there and maybe roll it back a little bit. I guess the most important thing is communication, being able to communicate with not only the taxpayers and the business community, but also the everyday worker who has to bear the brunt of all this, and sometimes bear the brunt in the form of unemployment.
Exactly, yeah, absolutely.
And so, well, now we move from to plan for Bay Area, the regional planning to restrict development. Okay, what's happening in the Bay Area?
So right now it's an issue that primarily affects the state of California, but we believe in the long term it's going to affect the entire nation because the Obama administration has endorsed what California is doing. It's something called the Sustainable Community Strategy. It's a state legislation, SB 375, that requires regional governments to restrict development in order to reduce carbon dioxide emissions. And it gives them wide latitude to do whatever they want, but invariably what they're doing is they're saying we're not going to allow development, we're going to push people into living into very urban tight neighborhoods, basically pack them in like sardines, get rid of suburbs and rural areas, basically where the middle class lives, and push them into the cities, put them on transit, and it's basically a huge boon to environmental special interests and public sector unions who operate and make money off these public transit projects. And that's exactly what's happening in the Bay Area. They passed a plan that's going to limit all future development, 75% of which must be in 5% of the region's surface area. So if you own property in the 95%, you're essentially out of luck. And they're saying that all this development has to happen on what are called public transportation corridors. They're putting everyone on BART, getting them out of cars. And one of the ironies is that, so we have challenged this plan, and about a day, I think a day after we filed our complaint, BART had a major strike. and refused to work for, I think, about 2 weeks. And it was ironic because the regional governments were coming in and saying, okay, we have this great plan. You're going to love it. You're going to get out of your cars. You're going to be in public transit. And it's all going to work out. And then BARD's basically saying, no, you're now on the hook. We've got you by the, we've got you. You have to give us, whatever we want. Because if you're stuck with this plan, you can't really bargain with us anymore. And, same thing with the environmental groups. In approving the plan, something which was incredibly unpopular in the Bay Area, environmental groups got paid off because they wanted something different and didn't get quite all that they wanted. They got a lot of it, but not quite all of it. So we're challenging it. The primary basis is that it's actually an incredibly environmentally destructive plan. So one of the things people often don't realize is that building out light and heavy rail does tons of environmental damage that often can't be made up for decades. Just CO2 alone, producing the rail and putting it in place, burns a ton of carbon dioxide. That alone takes decades to recover based on reduced car trips and putting people on rail. And as cars become more efficient, it's not even necessarily true that that's going to happen. So we think that the local regional governments that impose this plan basically misled the public and ignored them when they said that state law makes us do this, which is patently untrue. The greenhouse gas emissions reductions that are required by state law were already going to be achieved by improved vehicle requirements and improved gas regulations. And that alone would have accomplished it, something which the agencies acknowledge but bury that in the footnotes. And in the actual documents where they're selling it to the public, they said, no, this is the only thing we can do. Our only option is to restrict development and put you all on public transit. And the state law doesn't allow local governments to lie to the people like that. And, I think it's really key here because I attended the meeting where the plan was approved, and it was probably the most widely attended planning meeting I think I've ever seen. Most of these have, maybe a dozen or so people. This one had at least 200 or 300, the vast majority of which were against the plan. The public comments went 3 hours of people protesting the plan, saying they didn't like it. And ultimately, the regional governments ignored them and just did what they wanted to do anyway. And that's unfortunate, but we think it was wrong.
That seems like it's part of Agenda 21. Agenda 21 has been rejected by quite a few communities, even some in California. Some states have rejected that agenda. And what it seems to be calling for is regional government redoing our form of government, not only in the United States, but also in other countries as well, to perhaps to socialize us so that we could be brought into a new future with less imprint on the earth.
Yeah, planning departments, planning schools across the country have been teaching this idea that planners know what's best. Yeah. That people don't really know what they want. They need planners to come in and impose their will on the public. Right. And that's a very unfortunate thing that I think is clearly wrong, but it's the dominant understanding. Plan Bay Area is an interesting example of that because in the draft plan was actually quite racist. It said that as new communities, as the Bay Area grew, there would be increasing populations of Asian immigrants and Hispanic immigrants. And planners believe that these groups prefer a certain type of living, and they don't want single-family homes. They don't care about the American dream. And the plan was explicitly saying this about race, saying that these racial groups don't want it. They don't see the world the same way, and so we're going to give them what we think they really want. They didn't like that, of course, and so they removed it from the final plan, but the ultimate result is still the same. They're forcing everyone into communities they don't want to live in and saying, the old American dream, that's outdated. We don't want that anymore. So we're going to get rid of the suburbs, we're going to get rid of rural communities, and everyone's going to be in apartment buildings downtown. Well,
I think that we're slowly making some headway in trying to expose this thing. It's really terrible. Even though the people that are promoting it mean well. They see a brave new world, and that without pollution and with a small human footprint and back to nature and everything being happy. They don't envision people in starvation and or in slavery. That's not a part of their dream. And however, when countries adopt these totalitarian methods, these methods of big government, that's exactly what happens.
Yeah, I think unfortunately a lot of people only think about what their motivation is. Right. They don't think about what the consequences of decisions like this are going to be for other people.
and you can't hold them accountable once the tragedy is occurred.
Because they meant well.
They meant well. There's a special district tax challenge you're also working on.
Mm-hmm. Yeah, so this is a challenge to a scheme, basically, by a local government to extract new taxes and extract wealth from a property owner or developer in order to circumvent restrictions under state law that protect taxpayers from abuse by local governments. So what happened is a developer owned a large open parcel that he wanted to develop into a residential subdivision, and the city went to him and said, we're not going to give you a permit unless you agree to support our idea for a special tax for the future development. And under state law, special taxes have to be dedicated to some additional benefit for the people paying it so that they're not being abused. But that's not what happened here. The city said, in exchange, if you approve the tax, it's just going to go to providing the same sort of police, fire, emergency services that we provide to everyone else. There's nothing special about it, but this is an opportunity for us to extract a lot of money, so we're going to do it. And one of the unfortunate realities is that a primary protection is voting. But because this is to this point undeveloped property, there aren't any voters in it yet. The city recognizes that eventually the houses will be built and sold and there will be voters there, and they're probably not going to like paying all this extra money for the same services that their neighbors perhaps across the street are getting without paying this special tax, and might try to vote it down or challenge it in court, something which we're doing now. And I think this is probably part of the worst part of the plan, or what the city's doing, is that they've already announced that they're going to punish the people if they do that. That if someone exercises their constitutional right to vote, or their constitutional right to go to court and challenge what the city's doing, they're going to disclaim any obligation to continue providing the same services that are provided to all the other residents in the town. And that is really disturbing, because
that's extortion.
Exactly. I mean, you can't have constitutional rights if the government is allowed to retaliate against you for exercising them. And that's clearly what they're trying to do here. We think that's wrong, so we're also challenging that aspect.
Now, how is that going to progress? What are the steps involved with it?
So we have filed the case in the trial court. We are now seeking a decision declaring the tax void. That could take up to a year. Unfortunately, the wheels of justice grind very slowly. Cases like this can go a year or two if there's no appeal, or they can take as much as a decade if the government decides they're really going to dig in and fight. And we think it's possible this is a case where the government will dig in and fight, because if they win, there's a lot of opportunity for them to circumvent the protections that protect individuals and property owners and taxpayers quite easily by using this power to extort developers and property owners in exchange for permits, something which we think is flatly unconstitutional, something the PLF has actually been litigating for a very long time. There have been 3 cases on the question of whether the government can extort property owners in exchange for building permits, and all 3 in the U.S. Supreme Court, all 3 have said no, 2 of which we litigated ourselves all the way up to the Supreme Court. The basic rule in those cases is that because you have a constitutional right to use your property, the government can't look at property owners as essentially a piggy bank. That because the government can regulate property use to some extent and require building permits, for example, it can't leverage that power to extract wealth from property owners and extract favors from property owners that aren't a consequence of the property owner's plans or development. So the most recent case we had was a case called Kuntz versus St. John's River Water Management District that we litigated, I believe, 2 or maybe 3 years ago now. There, a property owner wanted to build a commercial development on his private property. The government came in and said, we're willing to give you the permit, but we want you to spend in excess of $100,000 to improve property the city owns miles away that has nothing to do with the project, will not be impacted in any way. And we said that's wrong, that the government can only make you pay basically for the consequences of your development. They can't look at you as a piggy bank, and that's clearly what they were doing in that case.
One of the things that you've been involved in is the Endangered Species Act. Mm-hmm. Our taxpayer group thinks that this thing is just nonsense. Mm-hmm. But you've been working on this, trying to make some headway. What's been happening in that field? So
I'm the lead attorney in a challenge to the constitutionality of federal regulation of under the Endangered Species Act. For those that aren't familiar, the Endangered Species Act is an incredibly broad and burdensome regime that basically says if you do anything that causes any sort of harm to a listed species, of which there are approximately 1,500 right now, regardless of whether you intended to harm a species or not, you can go to jail. And that can have very severe consequences, and it's very easy to violate. It sweeps in a lot of innocent activities. So some of the examples I like to give are, if you are a surfer and get within 5 football fields of a right whale, you can go to jail. Now, I don't know about you, but I'm pretty sure I wouldn't be able to identify a right whale and tell it from any other whale from 500 yards if I were on a surfboard. But the federal government has announced that if you make that mistake, you can go to jail. Where I live in Sacramento, there's something called the Valley elderberry longhorn beetle, which has habitat right next to the jogging path along the Sacramento River. Well, if while jogging I accidentally step on a beetle that's crossing the path, I could go to jail. I've committed a federal crime. We think that is flatly unconstitutional. The federal government has only limited and enumerated powers that are identified in the Constitution, and it's not the ability to regulate any human activity that affects a living thing. If the government can do that, it can do essentially anything. So I filed a lawsuit on behalf of my client People for the Ethical Treatment of Property Owners, arguing that this is unconstitutional, particularly as applied to something called the Utah prairie dog, which is a rodent that carries a bubonic plague and has essentially taken over a town. There are approximately 40,000 of them in Cedar City, Utah. They occupy lots of residential subdivisions, keeping people from building their homes, keeping people from starting businesses, and they've occupied the local airport and cemetery where they dig underneath runways, they eat flowers at the cemetery, they bark during funerals, and they dig amongst the cemetery itself. And so the city and the people that this community have suffered for 40 years and were basically ignored by the federal government, because it's hard to get the attention of a bureaucrat in Washington if you're a small property owner in southwestern Utah. So we filed the lawsuit, and I'm happy to say that we won in the district court.
Oh, right. That's good.
Yeah, always good to know on it. It was the first time a federal court imposed the Constitution's limits on the Endangered Species Act. There were 4 or 5 prior cases on the issue in other courts, all of which said this is fine, but adopting reasoning that, if true, would mean that the federal government has unlimited power, it can do whatever it wants. And that's clearly wrong, and what the court, in our case, recognized.
Oh, I understand. It seems like we need to have more supporters of the Pacific Legal Foundation.
I mean, we're obviously grateful for the ones we have, but we're always trying to find new avenues, new ways to reach people, and to get out the message about our cases.
If somebody wanted to join the Pacific Legal Foundation, what would be involved with that?
So we have a website, pacificlegal.org, where you can find out more about all of our cases and donate or become subscribed to all of our newsletters. We're also active on social media, so on Twitter we're at Pacific Legal, and Facebook Pacific Legal Foundation. And we do programs like this and speeches across the country to try to bring more attention to what's going on.
I think we've had the Pacific Legal Foundation as a guest several times over the last 6 years, and it's always been very informative.
Thank you.
And we also want to thank you for being our guest at our public luncheon today that the audience may not know about, but it was just fantastic.
It was my pleasure. It's always fun to talk about something that I care a lot about.
Yeah.
The reason why I and my colleagues do what we do is because we care passionately about the ideas that we end up working on.
We want to thank you for watching our Taxpayer Alert program, and we want to thank Jonathan Wood for being our guest.
Thank you for having me.